Hello again, everybody. This is attorney Mark Brunner. Thank you so much for joining me here today on Talking Texas Law. Well, today let's talk about subpoenas. What are they? How does one go about getting one? What happens if you are served with a subpoena? What needs to happen? Well, a subpoena really falls into two broad categories here in Texas. We're going to talk about trial subpoenas. Then we're also going to talk briefly about grand jury subpoenas. A trial subpoena is really probably issued in 95% of the time when we're talking about a subpoena. This is what we're talking about, a trial subpoena. This is an order from a judge requiring an individual to show up at a particular time, place, location, usually that judge's court, and to make that person available to offer testimony in a matter before the court. This could be for a trial. This could be just simply for a hearing. There also may be a subpoena for records or to bring documents, what's called a subpoena ducis tecum. Perhaps my Latin is a little off, but that's how we say it here in Texas. So again, person may be required to bring either themselves or with a subpoena ducis tecum to bring documents before the court. So how is this issued? Well, one of the litigants in the party, one of the parties in the case before the judge has to go to that judge or to the clerk of the court and make a request for a subpoena. So even though one side, let's say in a criminal matter, there's the defendant, there's also the state prosecutor or the county prosecutor. So let's say the county prosecutor asks the judge to subpoena a certain, let's say, doctor to court. Okay. Well, it is not the prosecutor's subpoena, it is the judge's subpoena. So that doctor can't just decide willy-nilly, you know what, I don't like that prosecutor, I'm just not going to show up. Well, it's now a court order. So it's not something that you can just blow off. Same thing in a civil case. One side, there may be some bad blood, it's a divorce case, let's say. Well, I don't like my wife's lawyer. I don't care if that guy wants me to show up and testify, I'm not going to show up. Well, it's not the lawyer that issued the subpoena. The lawyer requested the subpoena, but the court, the authority, was the one that is now requiring that witness to be there. So not something to be blown off or treated lightly. So what happens, and again, just about getting the permission, there's not really a very high standard that a litigant needs to show to the court or to the clerk to get a subpoena issued. It's not a very high standard at all. Really, they just need to show that there is a material need, that this person may have materials or testimony that may be relevant to the furtherance of their case. And courts are very liberal in getting subpoenas issued, and so they're not really frankly that hard to get. What do you do if you get a subpoena? You are the recipient of one. Well, what I always say is, don't freak out, reach out. A lot of times you can get a lot of information on that subpoena. You can look there and see, who is the court, who is the authority that has issued the subpoena. It may be a clerk's office, maybe a particular judge. You can certainly call that office up and find some more details. Generally, the subpoena on the face of the document is going to say which of the parties in a particular case were the ones that had requested that subpoena to be issued. So it may say, you've been subpoenaed in the state matter of, state of Texas versus John Jones, and there's a subpoena issued on behalf of the defendant, by such and such a lawyer. So you may be able to then contact that lawyer's office, find out some more information if you know nothing about the subpoena whatsoever. They may or may not tell you information, but here's one important thing is that, as a general rule, somebody else can't just give you permission to ignore a court subpoena. If a judge has told you to be at a place at a time, to make yourself available to testify, even if everybody else says, you know what, that case isn't going to trial, it's probably going to get reset or whatever, don't bother. You bear the risk if they're wrong and you're supposed to be there. What happens if so again, don't freak out, reach out. Try to find out some more information if you must. Talk to the clerk, talk to the judge's office, talk to the lawyers or whoever issued that subpoena, see if they'll give you some more information. Otherwise, you just got to make your plans to be there. What happens if you aren't where you're supposed to be? You are subpoenaed for a Monday morning, next month or something like that, a particular date and time and place, and you're just going to blow it off. Well, you are now subject to what's called a writ of attachment. This is an order that the judge can issue to a law enforcement officer to basically, here in Texas, to go and get you. Writ of attachment means to have law enforcement literally come and lay their hands on you and bring you now from where you are, however you are, bring you to court, to haul you to court. So if they're knocking on the door and you answer in your bathrobe, guess what you're going to show up in front of the judge in your bathrobe, to explain why you weren't there when you were ordered to be there. Again, you may not like the litigants, you may be busy, you have a lot going on in your life, all those excuses the court's heard, they kind of don't care, especially if you're not there to argue for yourself. Well, what happens if truly you get a subpoena and you can't make it, or you believe this is just harassing, or it's some kind of a tactic, and you think, frankly, for whatever reason, you should not have to honor it? Well, there are steps. There is what's called a motion to quash. You could hire a lawyer to try to pursue that, to try to offer to the court to say that there is some improper grounds for the issuance of the subpoena, that this person, you have really truly have nothing to add to this case, and that you think that the issuance of the subpoena was invalid, and you were asking the court to quash or to withdraw that subpoena. Very rare that this works. Again, in Texas, we have a very low standard for getting a subpoena issued. So for someone to come in later and say, you know what, that litigant, that requestor did not meet that standard, that's going to be a tough burden to fight. And frankly, you're probably going to have to show up in court anyway to fight on the motion to quash. So I'm not saying that means just roll over and show up. I'm just saying that, it pays to, if you really truly believe that the subpoena was issued in error or is being done for some sort of wrong purpose, seek separate legal counsel. Obviously, there may be a mechanism with a motion to quash that subpoena. So we've been talking really about trial subpoenas. There's another form of subpoenas out there that's called grand jury subpoenas. Now, this is not to come and offer testimony in court or bring your documents to a judge, but instead to bring yourself or bring your records to a grand jury that is sitting in a possible criminal matter, or has been impaneled to handle or discuss incoming new possible felony cases. So counties typically have a grand jury seated at any time. Some counties have multiple grand juries going on simultaneously. So you could get a subpoena from a grand jury asking you to then bring records or bring yourself to present yourself in front of a grand jury for possible testimony. Now, a lot of times, frankly, these grand jury subpoenas are really being used as a tool for the district attorney's office. They are the people that present new cases to a grand jury. They're being kind of used as an investigative tool by that DA's office to prompt you, coerce you, make you, whatever, appear, possibly bring records. Sometimes it is frankly kind of a nudge. They are nudging a possible suspect or possible defendant to, when they get that subpoena, they're going to freak out and they're going to reach out and they're going to say, what's the story here? And that DA's office may say, look, we can't talk to you directly. You've been issued a grand jury subpoena. We suggest that you go get counsel and they can advise you. And what they really mean is, have your lawyer talk to our lawyer. We're going to talk. So that I've seen that in many counties. That is ultimately, a lot of times, frankly, just a tactic. It's not a bad tactic, but it is a way for a felony prosecutor's office to kind of begin the dialogue with a possible suspect, witness, someone, a person of interest, whatever, because ethically that lawyer, that prosecutor can't just reach out to a civilian that may be the target of a criminal probe. They need to really do it lawyer to lawyer. That's really the best way to do it. So sometimes a grand jury subpoena may be sort of a prompt, a poke from the prosecutor's office to somebody else saying, please go out and get a lawyer, have them talk to us, we can get the ball rolling and tell you what you're going to need. Otherwise, it could truly be a time for you to come in and swear yourself in, not to a judge, but to a grand jury, a group of citizens that have been impaneled to talk about and listen to potential new criminal investigations that they're hearing about, that they may take action on. So again, be prepared for that. Also note that the issuance of a subpoena and who these subpoenas go out to is a matter of public record. So a clerk's office is going to maintain, if the state of Texas, let's say, subpoenas 10 people for a particular trial, well, the clerk's office is going to maintain a file of that, and it's all going to be public. Same thing with the defense counsel. If a defense attorney subpoenas 5 or 6 or 7 or 10 people to testify on behalf of a client, those names and those addresses are going to be public. Oftentimes, as people get closer to trial, both sides can kind of look at who has been subpoenaed by each side to kind of get a hint at who is possibly being called as a witness. Now, here in Texas, the state does have to announce 10 days prior to trial, give a formal list of witnesses to the defense counsel 20 days prior to trial for any sort of expert witnesses, but 10 days for any sort of civilian or lay witnesses. But the defense counsel is not required to do that back, to kind of reciprocate. So basically, the state has to reveal their witnesses. The defense does not have to reveal their witnesses in a criminal prosecution here in Texas. However, if that defense counsel goes out and subpoenas a bunch of people, well, now the state knows who the defense witnesses are likely going to be. So sometimes defense counsel may not go the route of a subpoena unless a witness is truly being elusive or hostile, hard to pin down, hard to find. A lot of times the defense counsel will just simply rely on just their own persuasion and goodwill to summon that witness there for a particular day in court, so as to not tip off the state as to who that defense counsel is going to call for witnesses. So again, there can be a little bit of game playing with subpoenas, but generally, if you're the recipient of one, kind of doesn't matter the why, it just matters the what. That you've got to make your plans to be there in court or be there with your documents, whatever's required, be there to that grand jury. If you need to seek legal counsel to advise you further, that's certainly a wise thing to do. Well, thank you so much, and if you like what you see here on Talking Texas Law, please consider subscribing to this channel. That way you'll get new updates as new matters are being discussed, and you will get notification as new videos are being posted. As always, this video is being offered for educational and informational purposes only. It's not to be construed as giving specific legal advice and does not take the place of a true sit-down legal consultation. And unless you are already a contracted client of mine, I'm not your lawyer. Well, thank you so much for joining me here today on Talking Texas Law. This has been Attorney Mark Brunner. I'll see y'all next time.